to summarize where we're at, the court, of course, had already considered the first of the two issues in the case, and that was whether Runyon v. McCreary should be overruled. And as we've seen, eventually the court decided unanimously that Runyon should not be overruled. That, of course, meant that Section 1951 still continued to apply to private discrimination cases. Now, this was very important to Brenda Patterson because if the court had ruled in the opposite direction, if they had overruled Runyon, then Section 1981 would no longer apply to private discrimination, meaning Patterson's case would be tossed out. She would lose and the case would have been over. But just because she won on the first issue doesn't mean she's won the case yet, because the court still needs to consider the second issue, which of course was the original issue in the case, and that is whether or not racial discrimination in employment is a racial discrimination in the making and enforcement of contracts. So the court then in conference discussed this issue, and of course William Rehnquist went first, and of course he ruled against Brenda Patterson. He'd made clear in his earlier remarks that he wanted to find some way to rule against Brenda Patterson, and he said no, she cannot use this law to bring her lawsuit, that racial discrimination that happens on the job, that happens after somebody has been hired, is not racial discrimination in the making and enforcement of contracts. Rehnquist argued that it only applied to anything that might happen before the employment contract was written or in the writing of the contract, but that it didn't apply to anything that happened afterwards. So he voted against Brenda Patterson. Of course, the court then went around the room in order of seniority, as they always do. And of course, William Brennan spoke next, and he took the opposite viewpoint. He said that the Civil Rights Act of 1866 does apply. And he said that Rehnquist's argument would simply render the law meaningless. If all that it did was criminalize things that happened before employment, then that would eliminate almost all employment discrimination cases. And Brennan argued that employers could simply hire black employees or Latino employees and subject them to the worst abuse. And as long as it didn't happen before they were hired, then no lawsuit could be brought under Section 1981. And of course, that's almost never going to occur. So when Rehnquist and Brennan took opposite points of view, as one would expect, they then went around the room and everybody voted as one would expect. White, Scalia, and O'Connor, the conservatives, voted with Rehnquist. Marshall, Blackmun, and Stevens voted with Brennan. And so what that meant was, once again, the court was tied on a 4-4 vote when it came to the most junior justice, Anthony Kennedy, who had now been on the court for almost a year. So Kennedy once again had the tie-breaking vote. And so far, of course, he had been unpredictable. And he was unpredictable again because in this case, he voted with the liberal majority that the law indeed did apply, giving the liberals a 5-4 victory. So Brenda Patterson was going to win her case. But of course, deciding who wins is only a small part of what the court does. The court then needs to write the opinions in the case. And the first thing that needs to happen is that the majority opinion needs to be assigned. In this case, William Brennan was the most senior justice in the majority. The Chief Justice, Rehnquist, was in dissent, and so he didn't have the ability to assign the opinion. And as a result, that fell to William Brennan, the most senior justice in the majority. Now, Brennan made a mistake here. Brennan almost certainly should have assigned the opinion to Anthony Kennedy. Anthony Kennedy was probably the least reliable vote in his 5-person coalition. He knew that the other 4, Marshall, Blackmun, and Stevens, were all reliable liberals. But Kennedy, of course, was normally a conservative, and he was casting a liberal opinion in this case. And so Brennan should have given Kennedy the opinion assignment to keep him on board and to allow Kennedy to write the opinion in a way that he would have been comfortable with. But that's not what Brennan did. Instead, Brennan assigned it to himself. Now, Brennan, of course, we talked about the fact that people tend to assign to themselves more often than to other people. And William Brennan probably thought that with his strategic instincts that he would be able to write an opinion that would keep together his 5-person coalition. But as we'll find out, that was probably an error. Because very soon after the vote and very soon after the conference, Anthony Kennedy starts to waver. 5 days after the conference, Kennedy sends Brennan a note. Kennedy apparently had been doing some reading. In fact, he had been reading a book about the post-Civil War era, the years immediately following the Civil War. Well, that's interesting because that's exactly the period of time that the case was involved with. This case involved the Civil Rights Act of 1866, and it was passed, obviously, right after the Civil War. And so Kennedy was reading a history of that particular era in American history. And he said that according to the book, the Civil Rights Act was directed at public but not private discrimination. In other words, the book made the argument that in fact Runyon v. McCreary was wrong. Now that's interesting because the court had just decided that Runyon was right, and they had decided it by a 9-0 vote. But now Kennedy was saying that he had some evidence that perhaps that 9-0 decision was incorrect. And more importantly, according to Kennedy, was the identity of the book's author. The book's author was a historian named Eric Foner. Now, Eric Foner is not particularly well known. You've probably never heard his name before. But the reason that that was significant to Kennedy was the fact that Foner was one of the 7 historians that had assigned the amicus curiae brief that we mentioned a couple of lectures ago that you may recall. There were 7 historians that wrote an amicus curiae brief that argued that the Civil Rights Act was aimed at private discrimination as well as public discrimination. But Kennedy said that in reading his book, it looks like Foner in his book took exactly the opposite position that he had taken in his amicus curiae brief. I did not wish to raise this at oral argument, but I do think Foner's brief is highly misleading, especially when it purports to present an objective view of the Reconstruction period. I thought you should be aware of Foner's published views. This note was not a good omen for William Brennan.